Hello, everyone. Welcome to this webinar being hosted by the Whitlam Institute and the Human Rights Law Centre on the right to a healthy environment. We have a few people that are already with us today and quite a few more that we're expecting to join us. But because our time is so limited and we have such a wealth of experience and knowledge in the panel, I wanted to start right on time so that we can ensure we have enough time to hear from everyone. So my name is Dastyari. I'm the Director of Research and Policy at the Whitlam Institute here at Western Sydney University. And I want to start by acknowledging the traditional custodians of the unceded lands I am zooming in from today, the Barramudigal people of the Darug Nation. I pay my respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples joining us on this webinar today. I also acknowledge that we're all on unceded land. We're all on not stolen land that we're zooming in from. And I want to acknowledge the traditional custodians of the lands that you may be zooming in from as well. As we discuss the protection of the environment today, it's really vital to remember that Aboriginal and Torres Strait Islander peoples have been caring for and protecting country for tens and tens of thousands of years, and their knowledge and stewardship are key to our shared future. It's a privilege here today to be exploring a fundamental yet often overlooked human right, the right to a healthy environment. Without a healthy and clean environment, many of our other human rights are also at risk, particularly for the most vulnerable in our society. Around the world, we're seeing a shift as more and more jurisdictions recognise the importance of enshrining environmental protections into law. And here in Australia, the Australian Capital Territory took a bold step in August, becoming the first jurisdiction in the country to include the right to a healthy environment in its Human Rights Act, something that I hope we get to talk about today. This milestone raises important questions about the rest of the nation. Today's discussion is going to be in a question and answer format, and our esteemed panel are going to discuss what the right to a healthy environment means for both people and the planet. Our first speaker is Amy Gordon, who is a Chief Campaign Director of GetUp. Previous to this, she had the role of First Nation Director at the organisation. Her expertise lies in campaigning, media communication and organising to develop and lead national campaigns, including last year's referendum, anti-fracking movements and 8 election campaigns. Before she joined GetUp, Amy worked with the Australian Youth Climate Coalition and SeedMob. Our second speaker today is Melanie Montalban. Melanie is currently Special Counsel in the Pasifik program at the Environmental Defender's Office. In this role, Melanie advises on some of the most pressing environmental matters in the Pacific region. Melanie's previous roles at the EDO include Special Counsel, Human Rights in the Safe Climate Program, and Managing Lawyer for the Australian Capital Territory, where she predominantly advised on climate justice and human rights matters and advocated for legal recognition of the human rights to a healthy environment in Australia. Our third speaker is Adam Beeson. Adam is General Counsel at the Australian Conservation Foundation. He has practice in the field of environmental planning law in the community, in the private sector and in government sectors for over 20 years. And our final speaker is Jack McLean. Jack joined the Human Rights Law Centre this year as Senior Lawyer in the Climate Justice Program. Prior to this, Jack was Senior Associate at Fife Finney McDonald, where he specialised in public interest litigation and represented Torres Strait Islanders in a class action against the Commonwealth regarding climate impacts. Before that, he worked on climate and human rights litigation at Equity Generation Lawyers, Justice Connect, Sunrise Project, and Environment Justice Australia. Thank you, panellists, for giving us your time today. So we'll dive right into our questions. We're hoping to finish right on time at 2 p.m. If you in the audience have any questions, please ask them in the Q&A button at the bottom of your screen. And if time permits, I'll try to ask them. In the meantime, I've got a couple of questions that I'd like to ask each of the speakers, starting with Amy. So, Amy, the First Nation Justice Team at GetUp has been engaged for years in supporting Aboriginal and Torres Strait Islander communities in protecting their country. Could you share what sort of struggles communities have been facing and the damage to country that is or could be happening?
Yeah, thanks, Az, and yeah, thanks for having me today. Very excited to be having this conversation and with all the other panelists. Yeah, and before I start, I just want to acknowledge that I'm here in Meanjin on Yagara and Turrbal country, and yeah, this area that I'm in, which is now known as West End, is the heart of resistance in Brisbane, and yeah, there's a lot of stories in this area that I feel really lucky and privileged to be living here. So yeah, my name's Amy Gordon. I'm a Gurrang woman, and so my family's country is in kind of around the Bundaberg region of Queensland, and my family was on a mission out there, and then was brought into Rockhampton, and then I grew up in Western Sydney, very, very privileged to grow up in Western Sydney. And my family is still all back there, and I now live here in Brisbane. And I'm the campaigns director at GetUp, and it's such an incredible space to hold because we get to talk to mob all across the country about their fights. And I think, you mentioned right at the start, as of like, there's 60,000 plus years of knowledge of caring for country in our blood, in our families, in our history. And, I think we can really see that today in modern practices of incredible work that the Aboriginal Rangers are doing, work up in North Queensland from mob on the Great Barrier Reef and the protection of reef and songlines up there, cultural backburning, particularly this time of year where backburning is so important all across the country, like mob really leading the way of how to do it and when to do it. But we're also on the front lines of some of the fights against the extractive industry of coal and gas projects. And, when you talk to mob all across the country, whether it's Gomeroi mob in New South Wales or mob in the Beetaloo or, mob fighting the Adani coal mine, they're real similar stories and similar fights that are going on. And, for the last decade, our team, both here at GetUp and at SEED and the OICC, have been working in the Beetaloo Basin with mob up there, and just wanting to name who they are, Yanyuwa, Garawa, Mudburra, Jingali, Alawa, Marawa, and Gadanji people who really have been, leading this fight against fracking in the Northern Territory for over a decade. And they were the ones that first kind of sounded the alarm of what was happening there. And I want to talk a little bit about this case study today, because I think there's a lot in here that is happening and replicated across the country. But, we got invited into community, over a decade ago, and they already had the MacArthur River mine happening up there. And this mine was already starting to change the way the flows of the local rivers, and was impacting water and was impacting hunting season, and all of that. And so they were really quite alarmed by the fact that, we had these companies coming in wanting to frack on this country as well. And they were really concerned about the impacts of water, particularly in the Northern Territory, who really rely on groundwater. Impacts of heritage, and also impacts of climate. And, over that decade since we were there, we've already seen the changing seasons and the impacts that, climate has. And, we talk a lot about climate impacts, and I feel like we're getting a bit better at it now, but we used to talk about it in terms of the future, but actually the impacts are really being felt already, and particularly in communities like in the NT, communities in the Torres Strait are really already feeling those impacts. When these fracking companies first came in, they said to these mob, the fracking sites will be the size of a billy can. Tiny, no impact, billy can, we'll be fine. We'll have a few around, whatever. 10 years later, they've actually grown. They've actually brought in these mega frackers from the United States, which are basically now the size of basketball courts and can move around like a robot, and drill 5 meters across and 5 meters down. And so we went from a billy can to basketball courts that can actually move. And that's kind of the scale that we're talking about. And if for people who've ever been to the NT, it takes about 10 hours to drive from Darwin to Borroloola, where all of this fracking is happening. And when they first started using these machines, one of the traditional owners, Nick Fitzpatrick, said it was like seeing a skyscraper in the middle of the bush, where this bush it's such beautiful country, but it was just this giant skyscraper there. And it was just really shocking to kind of mob to see that kind of happening on their country. And really at the heart of this fight is about the protection of water and the protection of the environment and the protection of, culture as well, of the right for us to be able to exist on country with our families right now, but also in the future. And that is really crucial of how we talk about the preservation of us being able to live on country with the impacts of colonization and the impacts of fossil fuels, of how we preserve a healthy environment to be able to continue that culture. And so really we've been focusing on how we win on this, and there are kind of two avenues. One is through a national water trigger, which would basically mean that the federal government would say, the impact on water is too great and these projects can't go ahead. And also a National Cultural Heritage Act, which would basically give, traditional owners veto rights over projects like this. And both of these pieces of legislation can be used in a lot of different of these fights across the country. Labor did commit to these reforms at the last election, and we haven't seen them implemented. And so there is a bunch of work to do to make sure that these reforms do get implemented. But, I think these are the types of mechanisms that need to be available for mob to be able to have a say over country, to have a say on what happens in the preservation of, protecting country and environment, and particularly protecting water, which is just really so crucial in this, current environment that we're in, around when we're seeing, rising temperatures. This year we've seen really early starts to bushfire season up there. We're seeing over 40-degree days already in the NT. And so I think there's just so much wrapped up in these fights around the bigger picture, not just in the Northern Territory, but across the country, that are kind of playing out in some of these fights that mob are on the front lines of.
Thank you so much for that incredibly powerful and compelling answer. I really appreciate it. Melanie, we'll turn to you next. Can you outline what the right to a healthy environment entails and why the Environmental Defenders Office has been advocating for its recognition?
Yeah, thanks, Az. And I just wanted to thank the organisers, both the Human Rights Law Centre and Whitlam Institute, for inviting me to speak today, and also the other amazing panellists. Thank you, Amy, for providing that overview of what's happening around Australia on country. So the first part of the question is, what is the right to a healthy environment? Forgive me, while I was preparing for this, my answer turned into a mini lecture, but there's quite a bit to unpack, so bear with me. But I wanted to start off by referring to an article one of my mentors wrote, Maria Antonia Tigre, which outlined the spiritual and philosophical foundations of the right to a healthy environment. She found that those foundations are drawn from a number of ancient sources, including religious and Indigenous cultural knowledge and customs, including First Nations peoples in Australia, that share this view of humanity as one part of this organic whole that includes or encompasses land, the sea, cosmos, and peoples. So what may appear as a new legal development, at least from the 1972 Stockholm Declaration, where it was first mentioned, it's actually an idea that's existed since time immemorial. And I think it would be offensive to suggest otherwise. So talking about the modern conception of the right to a healthy environment, there are two conceptions at law. The first is the standalone right to a healthy environment, and then the second is a precondition to the enjoyment of other human rights, which is also referred to as the greening of human rights. Today, I'm just focusing on the standalone right to a healthy environment. So the standalone right to a healthy environment recognises that all humans have the right to live in a clean, healthy and sustainable environment. But I'm just going to refer to it as a right to a healthy environment as a shorthand. In essence, it ensures and protects the quality of the environment. So this qualifier, healthy, requires that the different constituent elements of the environment, such as water, air, soil, all have technical conditions of quality that make them acceptable, in line with international standards, that enables people to live in dignity in their vital spaces. Now, this notion of vital spaces comes from the jurisprudence of the Inter-American Court of Human Rights, refers to the areas, territories or environments that are essential for the physical, cultural and spiritual well-being of individuals or communities, particularly Indigenous peoples and other communities that rely on the land for their well-being and existence. So these spaces are considered vital because they're intrinsically connected to the way of life, cultural identity and survival of such communities. While there's no universally agreed definition of the right to a healthy environment, the more, I would say, the mainstream concept of it is that it's comprised of 6 substantive elements and 3 procedural elements. This UN Special Rapporteur on the Right to a Healthy Environment defines the 6 substantive elements as being clean air, safe climate, access to safe drinking water and sanitation, healthy biodiversity and ecosystems, toxic-free environments, and healthy and sustainably produced foods. Note that each of these substantive elements has a qualifier that relates to the health of that component. So, for example, clean air, safe climate, healthy biodiversity. And this is consistent with the notion that the right to a healthy environment is in essence about protecting a certain level of quality of environment. Now, this list isn't intended to be exhaustive, and it will evolve as our understanding of state obligations under human rights law in relation to a healthy environment evolves. And this is reflected in the UN General Assembly resolution that recognised the right as a universal right, because it didn't explicitly name each of those substantive elements. And in all my advocacy, I've said the right should be broadly defined here in Australia so that it can develop in a way that is appropriate to Australia, and in particular for First Nations peoples. For example, in 2022, I co-authored a report on the status of the right to a healthy environment in Australia. And in that, my First Nations director said, the right of First Nations peoples to carry out cultural obligations to look after country and be with country is not captured in the Special Rapporteur's list of substantive elements. However, this right is critical to keeping country not only healthy, but also happy as a living entity, and is therefore intrinsic to the notion of a healthy environment from a First Nations perspective. So in this way, and I think consistent with what Amy has suggested, the right to a healthy environment can also be said to include the right of First Nations peoples to culture, and that it can also be not just about rights, but about responsibilities. The Special Rapporteur also states that the substantive elements must be accompanied by corresponding procedural elements, being the right to information, the right to access, right to information, the right to participate in decision-making, and access to justice. Environmental lawyers would be very familiar with these procedural rights, which are also referred to as community or access rights. The Inter-American Court of Human Rights has found that the right to a healthy environment is an autonomous right, meaning that it protects components of the environment, such as forests, rivers, and seas, as legal interests in themselves, even in the absence or certainty of a risk to individuals. The same court has said the right to a healthy environment has individual and collective dimensions. So in its collective dimension, it's protective of an essential quality of the natural environment per se, that constitutes a universal value that's owed to both present and future generations. In its individual dimension, it includes this freestanding right, and as well as its intrinsic relationship to other individual human rights. Finally, and relatedly, the right has a temporal element. So as I mentioned, the right to a healthy environment is owed to both present and future generations. The principle of intergenerational equity is well established in environmental law, and generations unborn have been found to be part of the environment. The International Court of Justice has said, the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. It's perhaps more contentious to say, from a human rights law perspective, that rights are afforded to generations unborn. Chief Justice Preston of the New South Wales Land and Environment Court talks about the intertemporal aspect of the right to a healthy environment. According to Chief Justice Preston, the right can only be enjoyed by people who are alive. This includes the present generation of adults and the next generation of children alive today. However, he acknowledges that the right will be held by each child of successive generations once born. So while the unborn cannot yet hold the right to a healthy environment, the right is their birthright. It vests on their birth. This understanding is consistent with the recent Committee on the Rights of the Child's General Comment 26 on Children's Rights in the Environment. So that's a very lengthy introduction to the right to a healthy environment, but if I could summarise for you, because I've been talking for a long time, the right to a healthy environment ensures and protects the quality of the environment, one that is healthy for individuals and communities to live a life in dignity in their vital spaces, whatever that means for that particular individual or community. It has at least 6 substantive elements, being clean air, safe climate, safe drinking water, healthy biodiversity, toxic-free environments, and healthy and sustainably produced foods. It can and should include the right to culture and caring for country, particularly for Indigenous and First Nations peoples, and therefore can be seen to include not just a right to, but also a responsibility to. It has 3 procedural elements: the right to information, the right to participate in decision-making, and access to justice. It's an autonomous right, meaning it protects components of the environment, even in the absence of harm to individuals. It has a collective and individual dimension, as it protects the environment as a universal value for humanity as a collective, but is also a freestanding right. And it has this intertemporal dimension, as it protects a healthy environment for present and future generations. So moving on to the second part of your question, as why has EDO been advocating for legal recognition of the right to a healthy environment in Australia? There are a multitude of reasons why we've been advocating for this for over 20 years now. But I think at the heart of it, or if I could pick one reason, it's really to do with environmental justice. When I was managing EDO's ACT practice, my work fell under a Healthy Environment and Justice program, which was underpinned by the right to a healthy environment and principles of environmental justice. The mission of that program was to empower communities to fight for environmental justice issues. We saw the right to a healthy environment as one such tool. At its core, environmental justice is about fairness. It seeks to address and prevent the disproportionate impact of environmental harm on groups who are vulnerable to such harm due to exclusion, marginalisation and oppression, and it ensures the equitable access to environmental benefits like clean air, water and land. I don't think it's the panacea to cure all environmental ills, and for that I think we really need systems change. But I do think it's a powerful tool to right environmental wrongs and to address the current triple planetary crisis we're in, being climate change, biodiversity loss and pollution. Thank you.
Thank you so much, Melanie, for unpacking that so clearly for us. The lecturer in me applauds you for it's such a complex, such complex ideas that you so succinctly explained for us. Moving on to Adam, one of the things that Melanie talked about was biodiversity damage. Can you give us examples of biodiversity damage that's happening right now? And how could a right to a healthy environment in the way that Melanie explained in our laws actually help us?
Thanks, Az, and thanks for inviting me to this event. Thanks to the Whitlam Institute and HRLC, and to Amy and Mel. I'm coming to you from Gadigal country, but I'm looking forward to returning home to Nipaluna, Hobart today, which is the land of the Muanina. Just before I answer your question, Az, I just wanted to say that in 1973, then Prime Minister Gough Whitlam actually launched ACF's member magazine Habitat. ACF's, for those who are unaware, a national environmental advocacy organisation. It's been around for almost 60 years. And I say that for obvious reasons, given the forum, and also because it's just an interesting example of the change in our politics that a Prime Minister would weigh in on a civil society's publication in that way, civil society publication. The second thing I just wanted to say is that ACF has done a lot of work in this space, and it's terrific to see this event taking place. We think it's really important, and more as an indicator or as a guide for folks on the call, that we produced in November of 2023 a significant report, The Children's Right to a Healthy Environment, an Australian Perspective 2023. And just like to acknowledge the enormous amount of help that EDO, and in particular Melanie, gave us in the preparation of that document. It's a good resource, I think, for people interested in this space, together with the report that Melanie mentioned, because it was a very detailed consideration of the substance of the right and how it is and isn't consistent with Australian law. One other thing on that, we did some polling around the same time. And the polling revealed that Australians between 13 and 24 years of age, 9 out of 10 of them believed that they had the right to a healthy environment. So to turn to your question, the example of biodiversity damage that I want to talk to is deforestation, land clearing. And I'm talking to that because it's something that's ACF is spending a lot of time on at the moment. The statistics are pretty grim, but I'm going to go through a couple of them to make the point, but also because some of our research has also indicated that a lot of Australians are unaware of the extinction crisis and the degree of land clearing that's taking place in Australia, and think that the Australian environment is in pretty good shape, which is not reflected in, for example, the most recent State of the Environment report produced at the Commonwealth level. In the last 20 years, about 7 million hectares of threatened species habitat's been cleared in Australia. To give that some context, that's about the size of Lutruwita, Tasmania, where I'm from. So it's a vast area. Australia has the highest rate of mammal extinction globally, and that's directly connected to the level of deforestation. There's been 34 mammals since invasion that are no longer with us. Deforestation for agriculture, and particularly for beef production, is causing significant biodiversity damage, and it's something that ACF is focusing on. To take one state, in Queensland, in the period 2016 to 2021, about 1 million hectares was cleared for beef production. About 700,000 hectares of that was koala habitat. And in Queensland, the threatened status of the koala has increased to endangered just in the last couple of years. We're also seeing emerging threats, in particular in the Northern Territory, in relation to cotton farming. So half of this country is used for agriculture, and a significant cause of the biodiversity damage we are seeing, subject of your question, is arising from land clearing associated with agriculture. So how could the right to a healthy environment help? I have taken a bit of a lead here from a paper that was delivered by Chief Justice Preston in 2022 in New York, which I commend to everybody to understand the content of the right, although I can essentially lean on what Mel's already told you, which is a terrific explanation. And I'll talk to three elements of it. First one being that properly implemented, that is, if it's framed correctly in Australian law, it would recognise biodiversity as important for human health via the provision of clean air, clean land, clean water. And with that recognition, the right is then protective of biodiversity and should provide an avenue to expand consideration in decision-making and regulation to capture biodiversity as a concept rather than what we really have now, which is species by species, site by site, community by community, as in, say, a vegetation community. And I think it's reasonable to say that that consideration in that framing gives us a good chance of reducing the amount of biodiversity damage that's arising from deforestation. The second element that I think the right to a healthy environment can provide is distinguishing from health to what I might call, I'm going to pick up a word that Mel used, which is well-being. So it would create a positive right directly connected to nature, and which, again, if properly implemented, goes beyond sustaining life to protecting biodiversity and nature, more biodiverse systems, again, for a human purpose, but that purpose being in relation to happiness, creativity, and culture. So that's as distinct from the right to life and health. And the third opportunity that I see it giving rise to, or push in the right direction, is a step towards recognising the intrinsic value of nature. So that biodiversity, which is key to a healthy environment, is seen to have value outside its human utility. Chief Justice Preston's article gives quite a few examples actually in international fora of how the right to a healthy environment has been invoked in relation to deforestation. I won't go into them, but I commend that to those on the call in the webinar. And the final thing I wanted to say about that is that it also raises the other side of the right, which is the duty. So a duty coming out of the right could operate in relation to legislation being put to Parliament in terms of the human rights review process, and then the way in which legislation is applied, whether it's in terms of regulatory approvals or enforcement, compliance, and so on. Thanks, Az.
Thanks very much, Adam. That was a fantastic answer. Jack, building on what Adam was talking about with all of this loss, we know, right? We know that human activities like pollution and habitat destruction, deforestation, are driving global heating through rising carbon and methane emissions. How much does the absence of a right to a healthy environment in our laws contribute to this problem that Adam's been talking about?
Yeah, thanks, Az. And just want to start by saying I'm coming to you from beautiful Gadigal country in Sydney, and really to thank the Whitlam Institute and yourself for hosting us. Human Rights Law Centre is really privileged to have such a stellar panel from people who are protecting country, across this great continent. A special shout out to Mel. A lot of the people who are on this call really don't realise the extent to which Mel has been a driving force, especially for us lawyers, but also communicating to the public, kind of driving forward the right to a healthy environment, both at the state and territory level, as well as at the national level. So I really commend to you the kind of EDO publications that have been released over time, which provide a really great summary if you're still interested coming out of this, this webinar. And yeah, look, as we've been hearing from Amy and Adam, Australia, we face a really serious set of environmental challenges, right? Air and water pollution, biodiversity loss and habitat loss, and of course the varying and devastating impacts of the climate crisis. And we know that environment's deteriorating under the strain of these crises. And we know that there is an intimate connection between that deterioration of our natural environment and the deterioration of the health and well-being, living standards, and the cultural and spiritual life of Australians, right? There is an intimate connection between the health of our environments and the health of our people, our families, and our communities. And so it should go without saying that governments across the country at all levels should be doing everything that they can, in collaboration and close consultation with Aboriginal and Torres Strait Islander people across this country, to stand in the way of that deterioration and address those challenges. Unfortunately, that's not the case at the moment. There's a shocking absence of legal protections in this country for people and communities suffering from the impacts of environmental and climate crises. It's actually an international embarrassment. If you look at our protection of human rights and environmental rights in this country, the right to a healthy environment is a really good example. 160 countries around the world, that's over 80% of UN member states, have protected the right to environment in some form, whether protecting rights in their constitution or through legislation or through regional bodies, to protect the right of people to access clean, healthy environments, clean air, healthy drinking water, and non-toxic environments. We have not, as a country, managed to come together and do that yet, even though we are, making some sounds at the international level, supporting the UN General Assembly resolution on a right to a healthy environment. But there is this lack of a legal culture implementing these rights domestically, and that's really where the rubber hits the road, because it's only when you implement these rights domestically do people actually have the legal protections. Are government decision makers actually forced to consider the impacts of their actions, and do people actually have the rights not only to challenge government decision making, but also to be part of that process, which is some of the procedural rights that Mel was outlining earlier. What we currently have is in federal environmental law is a system that's overly complex, it's highly ineffective, and it's horribly antiquated. The classic example is that the Environment Protection Biodiversity Conservation Act, which is the national piece of conservation environment protection legislation, it's over 20 years old. It's not a small act. It runs over 500 sections, doesn't mention climate change even once. A number of court cases have been run trying to make climate impacts relevant under that act. The structure of the legislation and the drafting mean that basically our hands are tied. So we know that at the federal level we need laws that protect people's right to a healthy environment. There are a range of thinking of the EPBC Act obviously is kind of targeted towards doesn't necessarily do its job in this regard, but biodiversity conservation. But if we kind of look at the other side of the coin and think about climate, there are a number of pieces of legislation at the federal level that relate to climate change. There's the Climate Change Act. There's a number of other acts that facilitate the the government's greenhouse gas reduction targets. None of that legislation protects the rights of people and communities to live safe from the impacts of the climate crisis. And none of it imposes real liability for climate impacts on companies, industries, or government decision makers. And so by failing to protect and enforce human rights of people and communities to live safe from harm, and that includes the right to a healthy environment, but also includes right to life, right to health, right to an adequate standard of living, down the list. Governments are effectively providing themselves and corporations impunity from the consequences of their actions, right? That's the result of the conscious and unconscious decisions that have been made over the past few decades in failing to provide people the rights and communities the rights that would protect their standard of living. And we know that there's really only one way to remedy this. It's by biting the bullet. It's by joining the international community. It's by passing a comprehensive and strong federal human rights act, bringing us in line with every other democracy, liberal democracy in the world that has a human rights framework. And in relation to the right to a healthy environment, honouring our commitment, well, I wouldn't even call it a commitment necessarily, honouring our vote at the UN General Assembly about the right to a healthy environment, and saying that people have a role to play in environmental decision making. They should have access to justice when environmental decision making and other decision making causes them harm. And people and communities have a right to access clean air, safe drinkable water, sustainable food. I mean, these are the building blocks of life, and it shouldn't be too much of a step to say that our federal politics should be set up to protect those fundamental principles of life. So I'll leave it there, knowing that we have a lot to cover. But yeah, looking forward to what our panelists have to say about other issues.
Oh, thank you, Jack, for that clear explanation of the woeful inadequacy of existing laws. That was fantastic. So more questions. Amy, I've got a question here for you. You and your team have a long-standing, determined record fighting for country for many years. You talked about that at the start of this webinar as well. Could you share what should be done to ensure Aboriginal and Torres Strait Islander communities have their country protected and self-determination is respected?
Yeah, and I mean, I feel like this is an interesting question in the context of the week that we've had a year after the referendum loss, and lots of feelings and thoughts about where we go to next. And I think the referendum was one thing, but I think there are real clear demands from communities about what is needed, and that is about self-determination, about communities having a say and control over what happens on their country, whether it is about, projects going ahead or projects not going ahead, whether it's about how, services are managed, and jobs and all of those things. It really comes back to decision making in communities. And I think there are a couple of different avenues that we're kind of looking at and exploring. And I think one is recognizing the deep connection to country that our communities have and what that does for a healthy environment, and that history of protection of environment, and for country. And I think there's a few different things of like how this plays into treaty negotiations. We have a really huge treaty negotiation happening here in Queensland, although the LNP has promised to wind it back if they win in the state election in a couple of weeks. We also have a really big treaty process happening in Victoria. But there are it's also starting to happen in New South Wales and other places. And so, really how treaty negotiations and land rights for mob and these conversations play into some of these big mechanisms that we already know kind of are coming up. And then I think, talked a little bit about how veto rights for communities to be saying no when projects are going to be impacting the environment, impacting country, impacting water. But I think really at the end of the day, the mechanisms we use, whether it's this, whether it's, the Human Rights, a National Human Rights Act, it's really about mob actually being able to have a say on what happens on their country. And that is the lens that we kind of look at this, and how community looks at this, of the say and the decision-making power that mob have over a healthy environment should be at the core of all of the conversations that we have as we move through these spaces around rights and land rights and treaties. Yeah.
Thank you, Amy. Adam, a question for you. What's ACF's approach to ensuring we have a clean and healthy environment?
Thanks, Az. Before I talk about ACF, I just wanted to acknowledge the amount of work that HRLC put into a Human Rights Act for Australia and how important that is. And just to flag that inquiry and the framework that was put in front of it did include a form of a right to a healthy environment. I was using the words properly implemented or something like that a minute ago. We don't necessarily agree with the precise framing, but the fact that it's in there is important. And it seems to me momentum is building. Mel mentioned a couple of instances where it's been embedded in Australia. We also have in New South Wales the Climate Change Net Zero Future Act 2023, which has specific reference to the right to a healthy environment. So I guess I'm just doing a little bit of a pitch about how important it is that we all get behind the Human Rights Act, and I suppose making the link to ACF and why we've participated in that inquiry and made submissions and so on, because of really going back to just what Jack said and how important it is that those rights are put into legislation for the sake of our environment as well. On ACF's approach, we sort of summarise what we do with three words: disrupt, create and activate. So disrupting business as usual is pretty self-evident. We do try and create solutions, come up with solutions to the problems that we're facing. And a really important part of our work is activating community, so empowering people to get involved in protecting nature. And we do that via two campaigns: Save Our Big Backyard, which is focused on nature, and we've got an emphasis, I mentioned this earlier, on deforestation, and particularly the supply chain through to supermarkets and the way in which we're trying to get those big entities to look at their supply chains and apply pressure down the chain to stop deforestation and land clearing. And our goal is that they've committed to that by the end of next year, and that land clearing in Australia is stopped by 2030. I'm going to keep this a bit brief. We also have a climate Renewable Powered Australia is the name of that campaign, which has an emphasis on exports and on electrifying Australia, powering us with renewables. Yeah, I mean, I don't want to do a massive ACF pitch, because I'd like to bring us back to a right to a healthy environment. But I guess I've just emphasised the areas that I see as having crossover with the discussion so far. Thanks, Az.
Wonderful. Thank you, Adam. Melanie, a couple of panelists have highlighted the role you've played in this movement, and we know that the EDO has been leading the conversation on the right to a healthy environment as well. Could you talk about the progress that was made in the ACT on the right to a healthy environment?
Yeah, thanks, Az, and thanks for Jack and giving me that praise. I should say the work that I have been doing at EDO is really building off those 20 years of advocacy of my colleagues. So I think I just happened to be at the right place at the right time. Thank you. So moving on to the question. So progress made in the ACT. So on the 28th of August this year, the ACT Legislative Assembly passed the Right to a Healthy Environment Bill, which in essence amended the ACT Human Rights Act to include the right to a healthy environment, stating everyone in this circumstance being ACT Territorians have the right to a clean, healthy and sustainable environment. So by recognising this right in the ACT Human Rights Act, ACT public authorities, including ministers, government agencies and public servants, will be required to act consistently with and consider the right to a healthy environment in making their decisions. However, even prior to this, recognition of the right would mean the ACT government and its agencies will consider the environmental impacts as an early and routine part of developing legislation. So under the Human Rights Act, any new legislation would need to be accompanied by a statement from the ACT Attorney General indicating whether that bill is compatible with the right, and parliamentary committees would be required to scrutinise new legislation for its compatibility with human rights prior to being passed by the Legislative Assembly. Now, this doesn't mean the ACT government is going to cease drafting legislation or make decisions that will negatively impact the environment or breach the right, but it will mean the ACT Parliament and all government will need to at least justify why these environmental impacts, such as pollution, biodiversity loss, or increased greenhouse gas emissions, are necessary. Now, unfortunately, this particular bill removed the right of action to the ACT Supreme Court. And so what that means is that ACT residents will not be able to challenge decision makers for failing to consider or make decisions consistent with the right to healthy environment, nor will the ACT Supreme Court be able to declare new legislation incompatible with the right. This is, in my view, given the current triple planetary crisis we're in and the effects that people are feeling right now, and Amy's mentioned the impact on country right now, I think this 5-year litigation bar is not acceptable, and I think that it shouldn't be replicated in any Human Rights Act that includes the right to a healthy environment. I don't want it to set a precedent because it in fact is inconsistent with the right to itself that includes the right to access to justice. But it is otherwise a positive development and builds on legislation that exists in Victoria and New South Wales. Adam mentioned the Climate Change Net Zero Futures Act in New South Wales. There's also the Environment Protection Act in Victoria. Both have a very limited version of the right to healthy environment, but the ACT is the first jurisdiction to have it as a standalone right in human rights legislation. Thanks, Az.
Thank you so much, Melanie. Jack, the final question is for you. You get the final word in the webinar today. Considering what the other speakers have discussed throughout this hour, how would including a right to a healthy environment in Australian Human Rights Act make a difference? And what progress has been made so far, building on what Melanie was saying?
Yeah, of course. I mean, it's probably helpful actually to go back a bit and just to give everyone a sense of where we're at with the Federal Human Rights Act. It's been a long, slow process, and my colleagues, as well as a number of other civil society organisations across Australia, have been really driving this process. In May of this year, the Joint Parliamentary Committee on Human Rights in the Commonwealth Parliament published what was really a quite amazing, expansive report where it recommended the introduction of a Human Rights Act at the federal level. And it actually went one step further to publish an illustrative Human Rights Act. And so you can actually go and read. And I really do encourage people, especially the lawyers, but not only the lawyers. I promise you, this is not a highly complex, confusing piece of legislation. It's quite simply put, as human rights legislation and protections often are. And you can actually see what rights the committee has proposed that be protected, and that that recommendation is based on a long and wide-ranging consultation phase that many of us kind of participated in. And as Adam mentioned, the right to a healthy environment was included in that illustrative draft. We agree that the exact drafting of that provision needs work. But also the committee recognised that and said that that was the right to a healthy environment in that illustrative draft was in particular need of further consultation, and we're very much, going to be part of that process. Picking up what Mel was just saying about how the right to a healthy environment is being implemented in the ACT. The substantive provision in the ACT law is quite good. It's this extra element of at least it's a lot better than the illustrated version in the Federal Act. Unfortunately, there is this bar on bringing the Supreme Court action, which won't repeat, but I agree with everything that Mel said on that point. So we need to make sure that human rights protections at the federal level, if and when they do come in, and we think it's imperative that they do, are strong, are consistent with international best practice, and ensure that government decision making is, government decision makers are, forced when making crucial decisions to be rights abiding. That there is a process, a robust process for new legislation and regulations to be reviewed on a human rights basis. And almost most importantly, the people that have those rights have the ability to challenge those decisions and seek access to justice. And so this is a really key moment in the fight for a Federal Human Rights Act. We haven't gotten this far in several decades. And I'm personally of the opinion that the passage of a Federal Human Rights Act is the single most important and would be the single most impactful piece of legislation passed in this country in decades, if potentially ever. You look through, and I really encourage people to look through the scope of the illustrative act. And just consider, if you just want to consider it from an environmental and climate perspective, how many of those rights intersect with climate and environmental harms. Not only the right to a healthy environment, obviously, but rights to life, rights to health, rights to protect children and families, culture. About half of the rights that are proposed have some sort of environmental or climate element. And we know that without a healthy environment, it's basically impossible to achieve those rights. And so we really encourage, any Human Rights Act to, not only include a right to a healthy environment, but to ensure that the role of our natural environment in promoting human rights and promoting human well-being is front and center of that process. And so we really encourage everyone to get involved, whether you're here in your personal capacity or as an organisation. Please do go to humanrightsact.org.au, and from there you'll see a bunch of different content about cases, human rights cases from abroad that provide guidance on what it might look like in Australia, and an ability to sign up and receive updates and get your organisation involved, because it's only by building a really strong movement and really building the political pressure that we can achieve this reform. And we know that from the past, when we stand together and really push for something, that's when we achieve lasting and effective change. So I'll just noting we're kind of coming up on the hour now. I'll just thank all the panelists for being with us on behalf of HRLC. And everyone who's joined, we really appreciate your interest. Implore you to join the campaign to introduce the Federal Human Rights Act, and we look forward to having you on future webinars about a range of rights that we're hosting over the coming months.
Perfect. Thank you, Jack. I'll just echo that. Thank the panelists for giving us their time, their expertise, sharing their knowledge with us. A big thank you to everyone at the Human Rights Law Centre, especially Danny Fadul, who runs the campaign manager for the organisation. If you're inspired to join the fight for a Federal Human Rights Act, please see what Danny's doing and check out all the links that Jack talked about. And thank you all for joining this webinar today. A recording of the event is going to be shared with everyone who registered. Thank you all very, very much. Hope you have a wonderful afternoon. Thanks.